The subcommittee will come to order. I was going to welcome all the new members to the subcommittee, but Mr. Cohen and I appear to be it, so good to have you aboard, Mr. Cohen. And Mr. Gowdy from my right. Ground rules, folks. I like to start on time and like to end on time, and I hope that is agreeable with everybody. You are familiar, perhaps, with the 5-minute rule. And the 5-minute rule, folks, is not done in any way to frustrate debate, but rather to facilitate the process. I mean, our jurisdictional bounds are broad indeed, and we will hustle along and do the best we can. So when you see that red light appears, that will be your signal that your 5 minutes have elapsed. Now, Mr. Cohen and I will not call in the U.S. Marshal on you then, but you need to wrap up. The 5 minutes rule also applies to members of the subcommittee, and we will try to adhere to that as well. I want to give my opening statement, and I'll recognize Mr. Cohen for his opening statement. Other opening statements will be made part of the record at the conclusion. Is that agreeable with everybody?
Yes, sir.
Today marks the first hearing of the newly constituted Subcommittee on Courts, Commercial, and Administrative Law. And I think we're going to have Mr. Smith to be with us, but he's not here yet. Chairman Smith has provided our subcommittee with jurisdiction over a number of important matters that I hope our subcommittee will address during the 112th Congress. In my view, one of the most important matters, let's strike that, let me pull it out of the way. One of the most important matters, I lost my place here, hang on a minute. It is to fine-tune our regulatory process, hence the introductory oversight hearing on the REINS Act. Many in the private sector have alleged that the Obama administration has cast a cloud of regulatory uncertainty over some parts of the economy. While it's no secret that our economy is still soft, perhaps even dismal, unnecessary or unreasonable regulatory burdens will continue to drive business investments, in my way of thinking, abroad. Examples of the need for improvement are prevalent in virtually every sector of government regulation. For instance, the Department of Health and Human Services implementation of President Obama's health care reform, the financial agency's implementation of the Dodd-Frank financial reform bill, the EPA's campaign against carbon dioxide, the FDA's approach to herbicide, and the Federal Communications Commission drive to regulate the Internet and allocate spectrum. I only mention these examples because they're widely recognized, and the fact of the matter is that fine-tuning is needed across the entire regulatory horizon. Our current regulatory regime has deep historic roots. Since the days of the New Deal, and especially during the 60s and 70s, Congress has delegated more and more of its legislative authority to federal agencies. This has been done through broad and vaguely stated laws that allow Congress to claim credit for addressing problems, but leave it to the various agencies to fill in the crucial details through regulations. The final risk of the wrong decision thus falls on the agencies and, of course, the economy and America's job creators. Congress too often escapes both responsibility and accountability. The Republican majority that came to Congress in 1994 attempted to address this problem through the Congressional Review Act. That act, you may recall, gave the Congress greater tools to disapprove agency regulations that harmed the economy, destroyed jobs, or otherwise were counterproductive. Over its history, however, the Congressional Review Act has not fulfilled its potential. During the 108th and 109th Congresses, the Subcommittee on Commercial and Administrative Law examined ways to improve the Congressional Review Act and better assert Congress' authority over legislative regulations. One of the leading ideas for reform was to amend the Act to preclude regulations from going into effect until Congress actually approved them. That is precisely what the REINS Act does for the biggest regulations federal agencies issue, those imposing $100 million or more in costs on our economy. Today, more than ever, we must consider and enact reforms that vindicate Congress' authority over the laws. The REINS Act is front and center among those reforms. Before reserving the balance of my time, I'd like to extend a warm welcome to our former colleague, Congressman David McIntosh. Good to have you back on the Hill, as well as the other witnesses. And Mr. Cohen, I said this before our other colleagues came in, but it's good to have all members, Republican and Democrat alike, on this subcommittee. And now I'm pleased to recognize the distinguished gentleman from Tennessee, Memphis to be specific, Mr. Cohen.
Thank you, Mr. Chair. I appreciate that. As you know, Tennessee was originally North Carolina, so in some ways we're colleagues, and beyond being colleagues here. And I would like to first pay specific attention to, for the new members and others, to the ranking member of the committee, the distinguished, the venerable, the honorable, the legendary John Conyers. Nice to be with you, and with Chairman Smith and all the other members. I look forward to serving with each of you as well. Who's also, he's not legendary yet, but he's honorable and a few of those other things that we'll incorporate by reference. Thank you.
With the gentleman yield just a moment, I didn't realize that Chairman Smith had come in. I didn't mean to ignore you, Lamar. Is Mr. Conyers here as well? Chairman, good to see you again, Mr. Conyers. I yield back.
Thank you. I would like to start by offering my congratulations to Mr. Coble, who has assumed the chairmanship of the committee. And when I was chairman, he was as nice as anybody was to me. Everybody was nice, but he was particularly nice, and I always was appreciative of that. You're a gentleman. I look forward to working with you. Mr. Franks was an outstanding ranking member, and we worked together nicely, and I look forward to serving with him. I'm honored to be working as ranking member, although I'd rather be working as chairman, but that's this Congress. Today's hearing provides us with the opportunity to debate the merits of H.R. 10, the regulations from the Executive in Need of Scrutiny Act, or REINS. It also gives us a chance to discuss the appropriate role of federal regulations in American life, a conversation I suspect we'll continue to have through this subcommittee in this 112th Congress. Although they do not explicitly say, proponents of the REINS Act appear to believe that almost all regulations are bad. All their arguments focus on the purported costs that regulations impose on society. Based on this premise, we've heard rhetoric about job killing that stifle economic growth and impair personal freedom. What such arguments do not seem to fully appreciate is that regulations can also benefit the economy by policing reckless private sector behavior that can undermine the nation's economic well-being, and came very, very, very close to doing it in 2008. Lack of regulations, and the economy of the world was on a precipice. Pulled off by President Bush and bipartisan members of Congress in passing the TARP and successive legislation with the Stimulus Act. We learned that the hard way in the 2008 financial crisis and the problems that ensued therefrom. We can look back to the Great Depression, when there was even more independence of regulations and lack of regulation, and see what followed there, Great Depression. Regulations can facilitate economic activity by providing clarity for regulated industries where the applicable statutory language may be too broad or too vague and lead to unnecessary confusion or even litigation. Regulations can also serve societal values that may outweigh economic growth. Most importantly, regulations help protect the health and safety of everyday Americans, including our children, our neighbors, our colleagues, our grandparents, and ourselves, and the public at large. The fact is that federal regulations help ensure the safety of the food that we eat, the air that we breathe, the water that we drink, the products we buy, the medications we use, the cars we drive, the planes we fly in, and the places we work. Indeed, most Americans are able to take for granted the safety of these things is assured because of the existence of federal regulations. The REINS Act threatens to make it harder for such beneficial regulations to be implemented. Under the Act, Congress must approve a major rule, one having an economic impact of $100 million or more, by passing a joint resolution of approval through both houses of Congress within 70 legislative days after the rule is submitted to Congress. The President must then sign the joint resolution of approval before the rule can go into effect. At the most practical level, I question whether the REINS Act could work. I've been in Congress long enough to understand that the crush of business before us will often be, more often than not, prevent us from giving due consideration and approval to the many rules that may be beneficial, and even ultimately enjoy the widespread support if we were to implement the REINS Act. As with the Congressional Review Act, the underlying statute that the REINS Act seeks to amend, this idea may seem better in the abstract than it will be in practice. Of course, I'm not ready to say the REINS Act is a good idea, even in the abstract. While I appreciate the attempt to reassert some congressional control over agency rulemaking, there are separation of powers that I think was spoken to members of Congress about recently, and Justice Scalia, I think, led that talk, and there could certainly be constitutional objections on separation of powers to the REINS Act, which we'll hear from our witnesses. There is a role for us, there's a role for the executive, there's a role for the judiciary. I look forward to our witnesses' testimony. I look forward to working with Chairman Coble and my other colleagues in the subcommittee for hopefully a meaningful 112th Congress. And I yield back the remainder of my time.
Mr. Cohen, I thank you, and I thank you as well, Mr. Cohen, for your generous remarks at the opening. I appreciate that. Statements of all members will be made a part of the record without objection, and I am told that Mr. Smith and Mr. Conyers would like to make opening statements, and I recognize the distinguished gentleman from Texas, the chairman of the full committee, Mr. Smith.
Okay. Thank you, Mr. Chairman, and Mr. Chairman, thank you for chairing this particular hearing, which I think is going to be one of the most important of the year. As you said, I also welcome our former colleague, David McIntosh. And David, I hope we get to talk a little bit more later on, but appreciate your being here too. Mr. Chairman, the American people in November voted for real change in Washington. One change they want is to stop the flood of regulations that costs jobs and smothers job creation. Yet another is to make Washington and Congress more accountable. The REINS Act makes that change a reality. Unelected federal officials for too long have imposed huge costs on the economy and the American people through burdensome regulations. Today, these regulatory costs are estimated to be a nearly incomprehensible $1.75 trillion, roughly $16,000 per household. Because the officials who authorize these regulations are not elected, they cannot be held accountable by the American people. The REINS Act reins in the costly overreach of federal agencies that stifles job creation and slows economic growth. It restores the authority to impose regulations to those who are accountable to the voters, their elected representatives in Congress. The Obama administration has under consideration at least 183 regulations that each would impose costs of $100 million or more on the economy. And when businesses have to spend these vast sums to comply with this massive regulations, they have less money to invest to stay competitive in the global economy and to hire new employees. These costs get passed on to the American consumers. In effect, these regulations amount to stiff but unseen taxes on every American. Last week, in a new executive order, President Obama reiterated the existing authority of agencies to cull outdated rules from the books and consider impacts on jobs when regulations are written. This order sounded encouraging, but added little to the rules that already guide the process of regulations. In the executive order, quote, distributive impacts and, quote, equity are specifically identified among benefits to be maximized. Job creation is not. The executive order is specifically written not to include regulations issued to implement the administration's health care legislation, and it carves out independent agencies charged to implement the Dodd-Frank financial reform legislation. And it won't halt the Environmental Protection Agency's drive to exercise authority it was never granted. So the most burdensome and costly regulations are exempted. The executive order, I hope not, may have been all style and no substance. Until the executive order produces real results, it is just a string of empty words. We must watch what the administration does, not what it says. In 1994, Congress passed the Congressional Review Act to reassert Congress's authority over the relentless regulation of the federal government. The act has been used just one time to disapprove a regulation. The regulatory tide continues and rises even higher. The REINS Act is needed to reduce the cost of the flood of regulations, free up businesses to create jobs, and make the federal government more accountable. Thank you, Mr. Chairman, and I'll yield back. Mr. Chairman, before I yield back entirely, I'd like to recognize a colleague sitting in the back of the room, Jeff Davis, who has been absolutely instrumental in promoting, advancing, and writing this legislation that we're discussing today.
I thank the gentleman. The chair is pleased to recognize the distinguished gentleman from Michigan, Mr. Conyers.
Thanks, Chairman Coble. I join in welcoming our former colleague, Mr. McIntosh, back here. It's very important. And I'd ask unanimous consent that the author of the bill, Representative Davis, come forward. I think he should be able to make a couple comments about the bill. And I'd welcome his sitting at the table, since there are only 3 people there anyway. There's plenty of room. But
Mr. Chairman, Mr. Conyers, I would be pleased indeed to have Mr. Davis come forward. I don't believe, though, he'd be eligible to comment, but we'd be glad for him to come forward to the table if he'd like.
you say he can't comment. He can't comment on his own bill in the Judiciary Committee, the keeper of the Constitution?
Well, Mr. Conyers, he was not called as a witness, and that's why I made that statement.
Okay. Well, I've got a few questions I'd like to ask him after the hearing, then, if I can. I'll be looking forward to doing that. I've got a statement that I'll put in the record so we can get to our witnesses. But the most important part of my statement is that I think we have a constitutional problem on our hands. And our former colleague alluded to it himself in his statement. And it's found in Article 2, Section 1, that I refer all of the distinguished lawyers on this committee to, and I'm sure we'll have enough time to go into this. The second consideration I'd like us to keep in mind as we go through this important hearing is that the REINS Act may not be tailored to the problems that it's supposed to address. We've got some big problems with whether this is feasible. The feasibility of this act is, well, let's put it like this. This would affect every law on the books. It's not prospective. It would involve every law that is on the books currently. Now, I don't want to suggest that the Congress isn't up to its work, but do you know how much time that would take to go through all of the laws, to get them, the regulations to the laws okayed by the House and the other body, as we delicately refer to them? It doesn't seem very probable that could happen. So when you consider the fact that we don't have the author of the bill testifying, and we're glad he's here, of course, but we also don't have the administration testifying. Why isn't somebody from the administration here? I mean, how can we be doing this? And I've been told by staff that we're going to try to report this bill next week sometimes. So, Chairman Coble, I'd like to, with all due respect, ask an opportunity to discuss with you the possibility of an additional hearing on this matter.
Well, if the General yield, this is an oversight hearing, as we know, and there will be a legislative hearing subsequently.
Oh, okay. Well, that's consoling. I'm glad to find out. Now, this is a great new process of order. We do the oversight hearing first, and then we have a hearing on the bill. Well, that makes a lot of sense. Why don't we have a hearing on the bill first? or we're oversighting the condition that has caused the bill to be created. Is that right?
Well, this is the oversight hearing. That's a legislative hearing will be scheduled.
Oh, okay. All right. Well, then I don't have to ask for another hearing. There's going to be another hearing on the bill. So I'm glad to know that, because I've got a witness or two in mind that I'd like to have partake with all the other distinguished friends of ours that are here today. So I thank you very much, Chairman Coble.
Thank you, Mr. Conyers.
I yield back the balance of my time and ask my statement be included in the record.
And all statements of other members of the subcommittee will be made a part of the record without objection. We're pleased to have our panel of 3 witnesses with us today. As has been mentioned previously, Mr. McIntosh, good to have you back on the Hill. Mr. McIntosh now practices at Mayor Brown LLP in Washington, focusing on issues before Congress and the executive branch. He's a graduate of the University of Chicago School of Law and a cum laude graduate of Yale University. Professor Jonathan Adler teaches at the Case Western Reserve School of Law, where he is the director of Case Western Center for Business Law and Regulation. Professor Sally Katzen is a visiting professor at New York University School of Law, and Professor Katzen also serves as senior advisor to the Podesta Group. Good to have each of you with us, and we'll start with Mr. McIntosh, and we recognize you, sir, for 5 minutes.
Turn on your mic.
Thank you. It's a pleasure to be back. I'm learning the technology. And thank you, Mr. Cohen and Mr. Conyers, for your remarks. Let me commend the committee for taking up this question in the oversight hearing of the regulatory process and the urgency for looking at, are there ways of making it work better to reduce the cost of regulations. And I want to commend Representative Davis for his work in introducing the REINS Act. When I was a member, the Speaker asked me to chair a subcommittee on oversight just on regulations in the Government Reform Committee. And we looked at a lot of the different regulatory programs, looked at the overall cost on the economy. And I have to say, as I was preparing for the testimony today after I received the invitation, I was startled at the magnitude of the cost of federal regulations. $1.75 trillion annually of costs imposed on the economy. It's about $15,000 per household. And in particular on jobs where for large businesses it costs $7,700 per employee to hire a new employee to follow the regulatory dictates of the various federal programs. And for small businesses, it's even more. It's over $10,000 per employee. As Mr. Cohen pointed out, those are the costs. You need to look at the benefits of regulations when you're making policy decisions, and Congress does that as it passes the laws, and the agencies are required to do that under longstanding executive orders. But the problem that I see that's happened, and we worked on the Congressional Review Act as a way of addressing that, is that balancing act of the particular type of mandatory requirement that gets set in a regulation versus the benefits doesn't come back to Congress for review once the legislation has been enacted and the regulatory agency has been empowered to act. We passed in 1995 the Congressional Review Act as one way to increase that formally, but as was pointed out earlier, it's only been used one time, and it's difficult for the political configuration to work, where typically you've got to have a resolution of disapproval go through both the House and the Senate and signed by the President. I think the only time it did work was when President Clinton's administration had proposed a rule and Congress acted and presented a bill to President Bush. about that regulation, and so you saw the political baton being handed from one party to the other, and willingness for Congress and the President to act. The REINS Act strikes me as an excellent way of really strengthening that effort. It's not applied to all regulations. It's carefully tailored to major regulations that have a significant and major impact on the economy. It, in many ways, addresses some of the constitutional questions that come up from time to time in the various regulatory programs, specifically whether Congress has delegated too much authority to the regulatory agency and needed to retain some of that authority in the legislative branch in order to perform its Article I duties. And also, as I point out in the testimony, there's some enhancements for presidential authority under Article II that Mr. Conyers mentioned, Article II, Section 1, where you have a unified executive, because the bill applies to both regular agencies in the executive branch, but also the so-called independent agencies, which the President would have some greater authority over as a result of the REINS Act. It's also carefully tailored to fit into what this committee is an expert at, and that's thinking about the processes that should be used for federal regulation. It merely says Congress is going to withhold part of its delegation and gives itself an option to approve the final result before that has the force of law. It's an addition to the Administrative Procedures Act and carefully written to be narrowly tailored to fit into that procedural change. The parties still have their rights under the Administrative Procedures Act for other problems that may come up. So I commend the committee for taking this up. I urge Congress to favorably consider the REINS Act and be glad to answer any questions when you need me to.
Dr. Adler?
Thank you, Mr. Chairman. There we go. Thank you, Mr. Chairman and members of the subcommittee, for the invitation to testify today. I appreciate the opportunity to appear before this subcommittee to discuss measures Congress may take to enhance regulatory accountability. This is a tremendously important issue. Federal regulation has been accumulating at a rapid pace for decades. In 2009 alone, federal agencies finalized over 3,500 new federal regulations. The growth of federal regulation has imposed significant costs on American consumers and businesses. According to estimates, as has been mentioned several times already, the total cost of federal regulation exceeds $1 trillion and approaches $2 trillion per year. This is substantially more than Americans pay each year in individual income taxes. Insofar as regulations impose substantial costs, they operate like a hidden tax. Now, just like taxes, regulations may be necessary. They may be important to address public ills or provide public benefits. And these benefits may be important, and it may be worthwhile to have many of these regulations, but that doesn't mean that they are free. The fact that regulations, like taxes, can both impose substantial costs and generate substantial benefits makes it that much more important that there be political accountability for federal regulatory decisions. The increase in the scope of federal regulation has been facilitated by the legislative practice of delegating substantial amounts of regulatory authority and policy discretion to administrative agencies. All administrative agency authority to issue regulations comes from Congress. Such delegation may be expedient or even necessary at times, but it also has costs. Excessive delegation can undermine political accountability for regulatory decisions and allow regulatory agencies to adopt policies that do not align with congressional intent or public concerns. All too often, federal regulatory agencies use their statutory authority to pursue policies that are unpopular or unwarranted, and all too often Congress is unable or unwilling to do something about it. This problem is magnified by the fact that agencies are often exercising authority granted years, if not decades ago. To take one example that's certainly been discussed already today, the EPA is currently implementing regulations to control greenhouse gases under the Clean Air Act, even though Congress has never explicitly voted to support such regulation. Rather, the EPA is utilizing authority enacted decades ago. The Clean Air Act's basic architecture was enacted in 1970, and the Act has not been significantly modified since 1990. If greenhouse gas regulation is warranted, this is a decision that should be made by Congress, not an executive agency acting alone. The REINS Act offers a promising mechanism for disciplining federal regulatory agencies and enhancing congressional accountability for federal regulatory decisions. Requiring congressional approval before economically significant rules may take effect ensures that Congress takes responsibility for that handful of regulations, usually only several dozen per year, that impose major costs and hopefully also provide major economic benefits. Adopting an expedited legislative process, much like that which is used for fast-track trade authority, ensures transparency and prevents a congressional review process from unduly delaying needed regulatory initiatives. Such an approach can enhance political accountability without sacrificing the benefits of agency expertise and specialization. Requiring regulations to be approved by a joint resolution that will be presented to the President also satisfies the constitutional requirements of bicameralism and presentment. The central provision of the REINS Act is similar to a proposal made by then Judge Stephen Breyer in a 1984 lecture. He noted that a congressional authorization requirement is a constitutional way to replicate the function of a one-house legislative veto. Requiring congressional approval for the adoption of new regulatory initiatives, Breyer noted, imposes on Congress a degree of visible responsibility. The REINS Act provides a means of curbing excessive or unwarranted regulation, but it is not an obstacle to needed regulatory measures supported by the public. If agencies are generally discharging their obligations in a sensible manner, the REINS Act will have little effect. If the public supports specific regulatory initiatives, the Act will not stand in the way. Indeed, it would enhance the legitimacy of those regulations Congress approves by making clear that such initiatives command the support of both the legislative and the executive branches. Above all else, the REINS Act provides a means of enhancing political accountability for regulatory decisions. Thank you again for the invitation to testify, and I'm certainly open to any questions you may have.
And you beat the red light illuminated, Professor, commend you for that. Professor Katzen, recognized for 5 minutes.
Thank you, Chairman Coble, Ranking Member Cohen, members of the subcommittee. I appreciate the opportunity to testify today. As is clear from my written statement, I am not a fan of H.R. 10. It's presented as necessary and desirable to combat an out-of-control regulatory process, but the bill, in my view, is not tailored to the problem that it is intending to solve. It is not well-founded, and it will have serious adverse unintended consequences, including fundamentally changing our constitutional structure of government. Now, we've heard a lot this afternoon about the costs of regulation. Everyone's citing $1.75 trillion, which is the high end of an extremely controversial estimate. Very few have talked about the benefits in monetized form. As someone who does, and I was the former administrator of OIRA during the Clinton administration, I do cost-benefit analysis. You look at both sides of the equations. And OMB, during both the Obama administration and the Bush administration, filed reports to Congress in which it monetized and quantified and monetized the costs and the benefits, and consistently over time, the monetized benefits exceeded the costs by a substantial amount, consistently producing net benefits for our economy and our society. We cut back the rules, we lose the benefits. Second, not all rules, not even all major rules, are alike. H.R. 10, in its infinite wisdom, exempts the migratory bird quota rule, because without that rule, which is a major rule, you can't shoot the birds as they fly to and from Canada. But there's lots of other rules. The industry, the regulated entities want and need rules that provide guidance, rules that provide predictability or certainty for their operation. I give in my written statement a number of these. There are rules that give life to programs like agricultural subsidies, small business loan guarantees, or medical reimbursement. Without the eligibility and accountability provisions, which come in the form of rules, major rules, you don't have a program, even though Congress has authorized it or modified it. No rules, no programs. Other major rules may be good because they reduce burdens. The OSHA rule, the infamous OSHA that everybody scorns, passed a rule on cranes and derricks, which reduced burden. It minimized the costs. Industry had asked OSHA for negotiated rulemaking and supported the clarification. Yet all of these rules would be caught by the H.R. 10 net. Now, the supporters say, as Mr. Adler did, well, there won't be any effect. They'll all go through. With respect, our experience during the 111th Congress, at least with the Senate, suggests that it is not easy. The drafters of H.R. 10 changed H.R. 3765, its predecessor, from allowing 10 hours of debate on the debatable issues to 2 hours of debate. But you still have a quorum call, you still have the vote, and you have non-debatable motions, which easily could exceed 4 to 5 hours. For the 65 to 95 major rules each year, the Senate is not going to find that time. It has been unable, with due respect, to find blocks of time to process nominations of administration officials or even judges. And so the result is that good rules, meritorious rules, important rules, will not get through, even though months, in fact years, have been spent with enormous resources devoted to sorting out the science and technical difficulties, with public participation, with analyses of all sorts of aspects, with numerous checks throughout the agency, with numerous checks throughout the administration, and subject to judicial review. What happens if the Senate doesn't get to them? Is all the time and effort and resources to go for naught? The same rule cannot be modified once it is final agency action without starting a rulemaking process over again. To say there is no effect is not to understand the administrative process. At a minimum, H.R. 10 introduces additional delay and uncertainty to an already lengthy and complicated process. And finally, for the reasons I set forth in my paper, I believe there are serious constitutional issues that are raised that fundamentally challenge the separation of powers principles our founding fathers incorporated in the Constitution. I sketch out some of the articles. I hear people referring to Justice Breyer's speech. Since 1983 and his response to Chadha, there has been a lot of law in the Supreme Court, and the Morrison versus Olson test is really critical. And I know that I have only 5 minutes. My light is red. I thank you, Mr. Chairman, but I do hope that somebody will pursue this during the questions so we can look at some of the existing law and practice in this field. Thank you very much.
I thank the witnesses for the testimony. We will now have members questioning the witnesses. We will apply the 5-minute rule to ourselves as well. I recognize myself for 5 minutes. Mr. McIntosh, in your view, what current regulatory efforts most highlight the need for reforms like those in the REINS Act, and why? Mike, I think, Mr. McIntosh.
Yeah, Mr. Adler mentioned the regulation of carbon dioxide, and my memory there was Mr. Dingell and I tried to present to the previous EPAs the full legislative history of the Clean Air Act amendments that made it very clear carbon was not to be regulated. And there was a lot of back and forth, and ultimately the courts have forced their hand. But to me, that shows an example of where if Congress had a procedure in place, they could reassert that intent even when the courts are driving the agency in a direction that perhaps the agency itself wasn't initially intending to go down. A second one would be the net neutrality regulations that the FCC has proposed. I think there will be a lot of litigation about the agency exceeding its statutory authority. I think if Congress had a procedure in place where they could easily pass that bill, and I think you'd see bipartisan support for a bill nullifying that regulation under the REINS Act procedure. I think that would save a lot of time and expense and uncertainty in the private sector as that litigation ultimately goes forward. And I think, and talking to my partners who specialize in the FCC Act, that very likely to be thrown out, that it once again would be a great example of how Congress could effectively ensure there's economic progress that's made by paying attention to and having a part to play in that regulation.
Thank you, sir. Professor Adler, in improving upon the Congressional Review Act, is not requiring Congress to approve at least some agency rules the next logical step? And in taking that step, what are the keys to ensuring that the REINS Act or any similar reform remains constitutional under the rule of INS versus Chadha? Mike.
Sorry, keep forgetting that. I do think it is the next logical step. I think a mechanism that forces Congress to actually say yay or nay to a substantial regulatory proposal is the next logical step to ensure that there is political accountability for major regulatory decisions. In terms of the constitutional questions, I think INS versus Chadha is very clear that all that is required is bicameralism and presentment. The Supreme Court has said explicitly time and again that it is axiomatic, that's their word, that all authority of federal agencies to adopt legislative-type regulations comes from Congress, and that agencies have no such authority absent congressional enactment. So unlike a case like Morrison versus Olson, where you're dealing with enforcement authority, where arguably, at least in some contexts, there is some residual of inherent executive authority or some inherent authority that executive agencies may have, there is no inherent authority in any federal agency to issue regulatory-type rules absent a congressional delegation. And if Congress wants to delegate less, if Congress wants to put conditions on the exercise of that delegated authority, it surely can. And not only did then Judge Breyer note this in his 1984 lecture, Larry Tribe, the noted constitutional law professor at Harvard, who was until very recently an official in the Obama Justice Department, likewise said that a requirement of this sort would be clearly constitutional. The last point I would just make very quickly, Mr. Chairman, is just that we've seen this already in areas that are far more sensitive than regulation. In the trade context, using this sort of process for fast-track trade authority is arguably a far greater intrusion on executive authority than anything regarding domestic regulation, because trade implicates the Foreign Affairs Authority. And I don't think many people argue that fast-track trade authority.
I want to try to beat the red light with Professor Katzen, if I may. Pardon me for cutting you off, Mr. Adler. Professor Katzen, you indicate that executive orders already constrain agency discretion to promulgate too many rules, but those orders haven't prevented a flood of regulation, and they can be withdrawn by the president, can they not?
Mr. Chairman, an executive order can be withdrawn by the president or his successor. 12866 has been in existence since 1993, September of 1993. And while there may be a flood, in your terms, of rules that have been issued, as I said, OMB has documented during the Bush administration as well that the benefits exceed the costs consistently over time. And I would just mention that Mr. Smith mentioned the recent last week, President Obama reaffirmed the executive order in his own executive order, and in fact, the very first sentence says that in order to promote the public health, safety, and the environment while protecting economic growth, innovation, and job creation. It was the first sentence of his executive order. So I think the record should be clear on that.
And my time has expired. I recognize the distinguished gentleman from Tennessee, Mr. Cohen.
Thank you, Mr. Chairman. Appreciate it. Let me ask one question. I may not understand this fully. As I understand it, Mr. Davis introduced this in the 111th and 112th Congress. Was it introduced, either your knowledge or anybody's knowledge, before that?
Last year as H.R. 30.
In the 111th, but before the 111th was it introduced? Was it Mr. Adler?
I don't know about the exact same language, but similar types of proposals have been proposed at various times.
That required a positive approval by the Congress?
Yes.
When?
The 1984 article that
Forget 1984. Let's come back to recent history.
I don't know if prior to last Congress when the last time such a proposal had been introduced, although I know then Congressman Nick Smith from Michigan has an article about legislation.
When was that?
I want to say it's 96 maybe or 97. I'm not exactly sure.
Yeah. And how about Mr. McIntosh? You know of anything?
I'm not aware of it.
So basically during the Bush years, it was all like wonderful and nobody even thought about this and the executive authority was great. and we didn't need this. It's only since Mr. Obama was elected president that we need to do this. That seems to be what's the situation. For 8 years, it was wonderful with Mr. Bush, and the executive did everything great. Let me ask you this question. You said, I think it was Mr. Adler, you said this isn't going to present a problem, that Congress can do it. Do you understand in the Senate that they have held up like 50 or 60 judges? And you know what's it called, a blue slip? You know what a blue slip? Yeah. Can you imagine the senators? I mean, that's the last don't ask, don't tell. You don't ask what you're going to get for it, and you don't tell what you get for your blue slip. They still have that in the Senate. How's that going to work? All these regulations, they do a blue slip. I need a park in my district. Done. Don't you think that's going to invite basically what I would think some nefarious type of agreement? Well, one senator can hold it up. Mr. Adler, is that right? One senator, under the rules we know today, can hold up appointments, can hold up rules and regulations?
Yes, under the way the rules are typically applied, they can, but blue slips are a courtesy afforded to home state senators for nominations. They are not applied to legislation, and my read of the bill would not allow holds of joint resolutions.
Mr. Adler, are you suggesting that we can write a bill over here that's going to change the Senate rules?
I think if the House and the Senate both pass a bill that is signed into law by the President that codifies changes to the rules for both chambers, as has been done for the Base Closure Commission, for Fast Track Trade Authority, for
you understand that one senator can hold up a bill
if the rules allow for it, yes. But I also know that there are probably about a dozen examples of the House and Senate passing legislation limiting the rules to prevent those sorts of holds by limiting debate and by requiring votes to occur within a scheduled basis. And the two most prominent examples are with the Base Closures Commission and with Fast Track Trade Authority.
Thank you, sir. Thank you. Ms. Katzen, let me ask you a question. You were here when we read the Constitution. Did you watch us read the Constitution from the floor in the well?
Actually, I did.
You did. And did you hear, I don't know who read it, I'm sure it was somebody's Article 2, Section 1. Something about all power being vested in the executive to carry out the laws. Tell us a little bit about a little kind of primer on what that means about the executive, and can they have the ability to execute our laws without rules? Could they do it without having any rules?
I think that's a serious problem because Section 1 of Article 2 vests all executive power in the President. That power includes the power to take care that the laws be faithfully executed. That's a quote from the Constitution. That means that when Congress passes a law, it is up to the President and a subsequent President and the subsequent President after that, whether they agreed with that law or not, to carry out the law. Now, for over a century, administrative agencies have been implementing or carrying out the law by issuing regulations. That's how it's done. And so for that reason, I believe that an attempt by Congress to strip the President of that authority with respect to major rules is tantamount to the act of Congress. I'm using Chief Justice Rehnquist's words from Morrison versus Olson, of one branch self-aggrandizing at the expense of another branch. Or again, using Chief Justice Rehnquist's words, the act of Congress which would impermissibly interfere with the President's exercise of his constitutionally appointed function. These are serious questions, and I wouldn't be so presumptuous as to say that I know how the Supreme Court would rule. But if they want to invoke Justice Breyer, I would refer them respectfully to Justice Scalia as well, who has been, among all the justices, the guardian of the President's powers.
Thank you, Mr. Chairman. I yield back the remainder of my time beyond the red light.
You didn't violate it too badly. The chair recognizes the gentleman from South Carolina, Mr. Gowdy.
Thank you, Mr. Chairman. Mr. Chairman, I would like to make my opening statement part of the record with your consent. I want to thank all three of our panelists. Mr. McIntosh, I will start with you.
Without objection.
Thank you, Mr. Chairman. What, in your judgment, is the proper balance between the executive branch and the legislative branch when it comes to rulemaking and enforcement?
Well, let me point out that the Administrative Procedure Act also constrains how the executive branch writes its regulations, the processes it must use before they can have the force of law. So there's a long tradition in our modern history of Congress asserting constraints over how the president and the executive branch can issue regulations. It's fully compatible with that for Congress to say, before this regulation that you're proposing, Mr. President, or the agency, it has to come back to Congress and sit there for Congress to give its approval of the content of that regulation. I think it's fully within Congress's power to do that. I would point out that for the century prior to the last century, there were no regulatory authorities or bodies, and the President was fully capable of exercising his duty under the Constitution to take care that the laws were faithfully executed. So I think this act, perhaps it would be hubris to say that it goes as far as to restrain the President's executive authority, because it simply doesn't do that. There are ways you can argue that, in fact, it enhances it, as I mentioned earlier, vis-a-vis the so-called independent agencies, because his signature on the bill approving the regulation gives him control over those agencies and the policies that they develop.
Mr. Adler, I may have heard you incorrectly, and if I did, I want to give you a chance to correct. I wrote down that you said there have been 3,500 regulations promulgated in the past.
In 2009, I think the exact number is 3,503, and of those, I don't remember the exact number, but several dozen of those were major. But the 3,500 number was all regulations in I believe, 2009.
All right, I'm just a prosecutor, so forgive me for not knowing much about civil law, but would the violation of a federal regulation be evidence of negligence in a civil suit?
It depends.
Depends on what?
It depends on the nature of the regulation. It depends on what's an issue. But, I mean, there are instances in which that could be evidence of that. It would depend. I guess it would really depend on a lot of factors, including the state law, what the state laws are.
Are there any criminal penalties connected with violations of federal regulations?
There often are criminal penalties associated with violating.
How can Congress abdicate its responsibility for criminal enforcement to a non-elected entity?
Well, I think you've hit on the key issue here, is that Congress, for expedience, has delegated lots of authority to administrative agencies to develop rules of conduct in a wide range of detailed and complex areas. And I think what we've overlooked is that it's ultimately Congress that is responsible for that authority. And especially when you have rules that are going to carry criminal sanctions, or, as in the case of the REINS Act, rules that are estimated to have a substantial effect on the economy, which is a rough proxy for a really major policy decision that will affect a large part of the country. I think it's certainly reasonable to say that we should make sure the people who are the source of the legislative power in the first place, Congress, where all legislative power is vested under Article 1 of the Constitution, is accountable for that decision, and that members of the public know whether or not their representatives believe that imposing that sort of rule is or is not a good idea.
Ms. Katzen, you do not challenge the constitutionality of congressional oversight, correct? You don't even challenge the wisdom of congressional oversight.
I endorse it.
So when you mention that there are constitutional infirmities in this bill, which, as I read it, is Congress reclaiming its responsibility/authority for oversight, what do you mean by constitutional infirmities?
I think the REINS Act goes well beyond oversight. And the chairman talked about in his opening statement fine-tuning the regulatory system. I think the REINS Act is a blunt instrument that goes well beyond oversight. What it says is that Congress must affirmatively approve an action that it has already delegated and on which a lot of work, effort, and resources have been spent in refining and developing and issuing a rule.
But you would agree with me, Congress could reclaim that delegation in the first place, right?
And that is through the Congressional Review Act does exactly that, because it satisfies the bicameral and presentment part of CHATA, and it says Congress is saying you can't do that. That's very different from saying before you do anything in this area, you must come back. Even though we've already delegated it to you, you must come back and get our permission.
What is the constitutional distinction between doing the two?
I think there's a significant difference.
I apologize, Mr. Chairman.
I think there's a significant difference between the two. And that's why the Congressional Review Act was originally crafted as it was, to be a change of the law, not a filter before which implementing a pre-existing law can go forward.
Thank you, Mr. Chairman.
Thank you.
Thank you, Chairman Coble. My ex-prosecutor colleague asked why the Congress doesn't enforce the laws. Well, as McIntosh and Davis and I know, we pass the laws. We oversight the laws. We do not enforce the laws. There's a little federal agency called the Department of Justice that enforces the laws. So that's my criminal justice lesson for the day. Now, this 1.75 trillion annually that has been raised here, I'd like to ask Ms. Katzen, how does that comport with the issues of the Congressional Budget Office, which has a different set of figures here? OMB said that major regulations promulgated over the 10-year period between 1998 and 2008 are estimated to have cost between 51 and 60 billion.
I would love to answer the question, but I know the red light will go off before I even get halfway there. The 1.75 comes from a study that was presented in the mid-90s that immediately raised all sorts of flags, both as to the assumptions, the methodology, etc. CRS did a very careful analysis, which I would commend to you, that shows the different problems that exist. Now, Congress ordered OMB to do the same thing, to do a real study. And what OMB did was to come up with the numbers that you had, which are they're very large numbers, but they're much smaller than the numbers. Congress, in its wisdom, said do the costs and do the benefits. So as you talk about the $43 to $55 billion in costs, they found $128 to $616 billion in benefits. So if you use the highest end of the costs, the lowest end of the benefits, you still have net benefits of $73 billion.
All right, let me ask you this. Who was it that made this authoritative statement allegedly about over $1 trillion? Do you know?
It originally came from a Tom Hopkins study, and then a gentleman whose name I would...
Mr. Adler, do you know?
I don't know off the top of my head, but I would just note that the OMB numbers that have been referenced exclude independent agencies and exclude non-major rules, which are over 90% of the regulations that are finalized each year. So to compare the OMB numbers with the other estimates is not...
Mr. McIntosh, do you know? But who
in the literature have cited that as they've discussed the cost of federal regulation.
So everybody says that somebody said it once and it's in a study somewhere, and so that's about it. Ms. Katzen?
That's fine.
Did you want to add anything to this?
Someone just handed me something which uses the name Mark Crane and Thomas Hopkins. and I think they are the co-authors of this 1.75 trillion. It's whatever.
All right. Let me ask this question. If this REINS Act, which is high up on the list of our new leadership's agenda, is the fourth piece of legislation introduced, what would this do to health care reform? How would you take an enormous piece of legislation like this, and I think Obamacare is going to be a congratulatory remark in history. How would this affect it? Wouldn't it just stop it in its tracks?
It depends on what members of Congress feel about it. If a majority of those in both houses of Congress support the regulations that are necessary to implement that law, then it would go on as before. The only thing that would stop it under this, under the REINS Act, would be is if majorities of Congress don't support those regulations. It ensures essentially that the American people get the sort of regulatory policy that the American people want, and I would think that that's a step towards greater political accountability.
Well,
and more
wait a minute.
rulemaking.
The majority of the Congress already passed the bill, and the president signed it into law.
But congressional opinions change. Congress repeals statutes, revokes statutes, alters statutes.
Well, that's
and one of the problems is you don't merely have legislation that was enacted last year.
I ask unanimous consent for one additional minute. Thank you, sir. Now look, gentlemen and lady, you all know that anyone that wants to challenge a regulation, all they have to do is walk into the nearest federal district court and sue away. And we have regulations that get reviewed and modified or kicked out.
But courts
What's wrong with that?
Nothing, but courts don't review the policy merits of regulation. Courts don't ask, is this regulation a good idea? Are the costs worth the benefits? Is this something the American people support? What courts look at is the non-policy questions. Were the rules followed? Was there, and those are two separate questions.
But
this body should be responsible for the policy questions.
But we just passed the health care months ago. You mean we got to go back and look at it again?
I think that when you have major legislation and agencies are implementing that legislation, it's
a good
idea for Congress
You know what
to
REINS sound like to me now? It sounds like a backdoor way of legislating again. And when they're charged with actually just making the rules to implement a bill already signed into law. Thank you very much, Mr. Chairman, for your generosity.
Thank you, Chairman. I'd like to follow up on the comment that was just made by Mr. Conyers when he said the individual can, who's ever objecting to the rule can sue away. Who pays for that? Who's the person who has to bring that lawsuit? Usually it's the small business owner. Is it a farmer? Is it a gentleman who's objecting to that regulation? I'll ask Mr. McIntosh that question.
Yes, sir. You're exactly right. It's the private party that's been affected by the regulation. And their recourse is, in fact, very limited in they have to argue that the agency failed to follow its own procedures or acted arbitrarily and capriciously, not that they disagree with or they feel it's unfair that the regulation imposes burden, say, on wheat farmers but not on corn farmers. And the law says to the agency, the Department of Agriculture, you go and allocate what should be planted on the land, and do it in a way that maximizes the return for agriculture. Well, if the farmer who's adversely affected by that wants his day in court, all he can say is, well, sure, they allocated it, but they didn't give me my allocation. The court says, sorry, you lose. They had to make that decision. And I think Mr. Conyers' later remark reflects correctly what the REINS Act would do is say that decision, who gets which allocation for what crops to do, should actually be a legislative decision. And So in many ways, what the bill does is correct a constitutional deficiency that's inherent in the regulatory program, where the accountability for legislative decisions like those never comes back to Congress. And
Yeah,
this is the
and
way
and correct me if I'm wrong, Mr. McIntosh. When, that bureaucrat who's creating that rule, he's not an elected official, correct?
No, he would be typically a civil servant or signed by a person appointed by the president and confirmed by the president.
So when I go talk to my small business constituent or my farmer in my district, and he objects to the policy, I can't go to him, well, you know, we'll vote that guy out the next time around because we disagree with that policy. He's essentially stuck with that rule other than the courts that are available to him. Is that a fair assessment?
His political recourse would be to join others to vote enough members of Congress to change the law, or to vote a new president who would change the regulation, direct his agency.
Okay, I appreciate that. There's been a lot of objection that I'm hearing in this testimony that one of the problems is the workload that would be put on Congress, finding the time to go through and develop that. Wouldn't we face that same problem if we went through the enabling legislation and amended the enabling legislation? Wouldn't that be a tremendous workload on Congress? And to go back, and no one objects to the fact that Congress would have that authority to do it, do you? We could go back through each of the pieces of legislation, change the enabling authority, and clarify our intent as to what we meant from Congress. No one objects to that, correct?
Nope. Right.
So that burden on Congress would be bigger, I would argue. Am I far-fetched on that conclusion, that would be a huge burden on Congress?
Yes, it would. I mean, back in 1995, we thought about doing that to address a lot of the regulatory problems, and some of them got dealt with and others didn't. Let me take those 2 seconds to brag about you all. I actually think Congress can handle that burden. Now, the Senate continues to mystify me, but the people who
not alone.
that body say they get things done by unanimous consent ultimately. But I think it can be done.
Thank you. I yield the balance of my time.
Thank you, Mr. Chairman. Mr. Adler, isn't it correct that regulations that pertain to clean air, these are the regulations that you're speaking of being able to stop?
Well, any regulations that would be major regulations.
Air quality, water quality.
Yeah, the examples I gave, there weren't.
Well, no. I just want you to answer my questions now. Water quality, air quality, correct?
Yes, Congress should be held accountable for those.
What about food safety?
I think members of Congress should be willing to vote to be held
What
accountable.
about drug safety?
I think members of Congress should be held accountable by voting on whether or not those regulations are a good idea.
What about financial reform?
Again, Congressman, I don't think members of Congress.
I mean, that is covered under, these are regulations that are brought to bear on big business and industry.
Yes, and
primarily,
and I think
all right,
having members of Congress vote is more accountable than having decisions made in agency.
Things like the health and safety of workers. You want to be able to stop those kinds of regulations from becoming the force of law.
No, I want my member of Congress to have to vote on that decision. I want to know whether or not my member of Congress supports it.
Well, tell me now, how, you contend that $1 trillion per year is what all of these regulations cost. How many new regulations are promulgated yearly that have that economic significance?
That's the aggregate effect. The major regulations between 2000 and 2009, the number of major rules that would be affected by the REINS Act has been between 50 and 80 per year.
Okay, and you're familiar with the attributes of the Senate,
yes,
in terms of them doing their work.
Yes, and that's why the REINS Act
you're
severely
pretty aware of the fact that one of those attributes is not the ability to move quickly. Is that correct?
I agree with that, and I think the REINS Act addresses
that.
that.
You've heard that before, and you know that to be a fact. Isn't that correct?
It's correct.
The Senate does not move quickly.
The Senate has to be forced to move quickly, and I think the REINS Act accomplishes that.
And so a obscure regulation, you think would be enough to cause them to set aside all of the judicial appointments and other important treaties that need to be ratified, all of the legislation that Mr. McIntosh gives us credit for producing here in the House, but because of an obscure regulation, they would suddenly spring into action. Is that what you want us to believe?
I don't think a regulation dealing with clean air or clean water or financial services or some of the examples you gave that costs more than $100 million a year by the executive branch's own estimates is an obscure regulation.
Well,
I think
tell
those
you now well, let's talk about obscure regulations. Who would decide, or how would it be decided that a regulation should be subjected to the congressional review under the REINS Act?
The executive branch's cost estimates would determine.
Okay, who would bring that to the attention of Congress?
The REINS Act has a procedure where that information is automatically transmitted to both houses of Congress with the regulation once it is finalized.
Who would do that?
I'd have to check. I think both.
Would it be the U.S. Chamber of Commerce?
No, the agency does it, and I believe the Comptroller General that heads the Government Accountability Office is responsible for submitting that to both houses. And then within 3 days, legislation is automatically introduced, or the joint resolution is automatically introduced in both houses. The last draft that I recall reading.
So there's some ability for politics to infect the process of actually producing the legislation. Then.
Actually, no. The way the REINS Act is drafted, there's no amendment.
It would be a government bureaucrat that would do that?
I spent a lot of time doing regulatory policy.
How do we get
DC,
politics?
I'm much worried about backroom deals in regulatory agencies than I am in up or down votes on the floor of the body of the whole.
How would we get politics, Mr. Adler, out of the rule-making process?
We haven't
and aren't we, by subjecting the rule-making process to congressional dictates, aren't we, by the very nature of what we do here in the House, subjecting these rules to politics?
Well, rules
and influence, political influence with campaign contributions and whatnot?
Rules that govern private behavior are things that political officials should be held accountable for, and I believe that sunlight is the best disinfectant, and requiring all members of Congress to vote up or down in the body of the whole is far less subject to special interest manipulation than leaving things in the halls of regulatory agencies. Your small businessman, your small homeowner isn't spending time at the FCC or the EPA or the USDA lobbying on regulations. They deserve to know how members of Congress feel and see them vote.
We just want to remove all regulatory action here in Congress. Less government, let's cut regulation, and let's allow the members of the U.S. Chamber of Commerce and other large businesses that traditionally shut out small business.
Let's
just let them run roughshod over society, and whatever will be, will be. I appreciate it. Thank you, sir.
The chair recognizes the gentleman from Arizona, Mr. Price.
Well, thank you, Mr. Chairman, and thank all of you here for being here today. Yes, Mr. McIntosh, my first question would be to you, sir. You know, it occurs to me that not only the process here, but the mindset in which agencies write their regulations could be one of the most significant advantages of this legislation. Because if I were the director of an agency and I were writing regulations and I knew that it was going to be subjected to the scrutiny and oversight of Congress, that Congress is going to have to approve it, I'd be pretty careful how I wrote that. I would make sure that it was regulation that would comport with a lot of common sense and that could withstand the rigors of the legislative process itself. So with that, since it only requires Congress to approve major rules, but it could affect and change the culture of the agency, in what way do you think that would improve all rulemaking, or do you think I'm just all wet here?
No, I think you're exactly right, that the prospect of having the work product that the agency does in developing a regulation be scrutinized in a debate in Congress and voted up and down, will have, as it does on every other decision the agency makes where Congress has expressed an interest, has an impact on their thinking and their calculation about it. And that provides more accountability ultimately to the citizens who vote on members of Congress. That same accountability, by the way, is also in the Congressional Review Act. It's more attenuated. But you can still, by having a discharge position in the House to stop a rule, rather than the presumption of it, with the presumption being that it goes forward, or 30 members of the Senate can have a discharge position. The mere prospect of a debate, even if everyone assumes that won't pass, I think can also have a salutary effect on the agencies and their deliberations. So I'm encouraging members of Congress, while you're deliberating the REINS Act, to use your authority under the Congressional Review Act as well. Again, it comes down to sunshine, which Mr. Adler mentioned. The bringing things out into the public debate has a tremendous benefit on all of the actors involved.
Well, thank you, sir. You know, I know there's going to be, as already manifest here, some debate as to the constitutionality of the legislation. I for one, am fundamentally convinced that it is constitutional, but I want to, be open to potential dissent here. Those who cite Article 2, Section 1 of the Constitution obviously are citing that executive power should be vested in a president. And of course, some of us would cite Article 1, Section 1, that the legislative power is vested in the Congress. And it seems to me that regulation is certainly has a lot of the same characteristics as legislation. So if you're going to make that case, it's important to consider. But in constitutional terms, Mr. Adler, is there any critical substantive difference between the REINS Act and a statute that treats new regulations as simply proposed recommendations to Congress for legislative action?
No, I don't think there's any significant difference, and I think both are clearly constitutional under existing precedent.
I'm going to give Ms. Katzen an opportunity to at you here in a moment, but I wanted to find out why do you postulate that this is constitutional? Is there anything that you would point out in
a couple things
particular?
I mean, the bicameralism and presentment requirements have to be satisfied. Both would satisfy that. I think that the Supreme Court has made clear repeatedly in numerous opinions, as have lower courts, that all authority to issue regulations must be expressly granted. It is not, there is no residual authority to issue regulations that comes with other grants of authority to agencies. It is not something that is seen as inherently executive. It is something that for the most part, the majority of federal agencies did not enjoy until the 1970s. There were some exceptions. And the presumption had been that unless agencies are expressly granted the authority to issue legislative type rules, that's an authority they lack. And Congress is not obligated to delegate that authority, and if Congress wants to restrain that authority in some way, such as it does here, there is no constitutional problem, and it doesn't create the sorts of concerns that might be raised if, for example, Congress sought to impose similar limits on the exercise of, say, prosecutorial discretion or other things that are closer to the core.
I understand. No, that's a good answer. Well, quickly then, Ms. Katzen, Justice Breyer and Professor Tribe of Harvard have both published articles supporting the view that the REINS Act is constitutional, and I know you know that. But could you specify for us why you think Mr. Adler is wrong, or why that Justice Breyer or Professor Tribe are wrong? And do you think there's any merit to their views whatsoever?
Well, thank you for that open invitation, and the light is red. But if I may answer?
If you, briefly, if you will, Professor.
I will try. I think Justice Breyer, who was then a judge, not a justice, was engaging in what he often does, which is extremely creative, more theoretical than practical analysis in this article, which I have read very carefully. And I think one of the most important things is that he sees it as a replacement for the one-house veto, which was invalidated in Chadha, and he saw it as a case-by-case, going through each of the statutes rather than an across-the-board blanket provision. But most importantly, when he finishes, he makes it very clear that it is neither practical nor desirable. He questions the wisdom of it. And if you read the entire article, it's well, we could do this kind of stuff, And we can think about these kinds of
So
things.
in other words, he thinks it's stupid but constitutional.
He
Yeah.
thinks
Gentleman's time has expired.
but this was before the last several decades of Supreme Court decisions in Morrison versus Olson, Mistrada, a few other cases, in which the court's been very clear that separation of powers has a life beyond. They're looking at it on a functional basis.
The time has expired, Professor, if you'll wrap it up.
Thank you, Mr. Chairman.
Time's expired.
Yes, sir.
The gentleman from Illinois.
Thank you, Mr.
Quigley.
Chairman. You know, I'm still relatively new here, but I learn something new every day. Today I learned that it's not good when someone who's not elected is enforcing our laws, especially criminal ones. So the next time a police officer stops me, I'm going to say, who elected you? Or FBI agents, or state's attorneys, or just go on down the line. In the end, the only person who's elected in the executive branch is the executive. At the county level, I suppose that's the state's attorney. But in the end, there's some delegation. This isn't 1776. It's a far more complicated world. And ladies and gentlemen, I would respectfully suggest or defy you to say, I'm not going to think about regulation today when I get on this commuter airliner. And I'm not going to wonder or worry about how many hours sleep that pilot got last night. When you come to my hometown in Chicago, the morbidity and mortality capital of the United States for asthma, don't think about regulation. Or if you drink our tap water in Chicago, which has chromium levels, not in the lake, but in the drinking water, 3 times higher than the new, I know it's a bad word, regulation proposed in California. It's the Aaron Brockovich chemical, if you recall. So you can decide now, or you can decide when you have your eggs in the morning. 1 million cases of salmonella last year. I understand what we all understand, that the president was trying to strike a balance here. That over 200-year friction between the executive branch and the legislative branch. And it gnaws on you when you don't like what they do. So you want to change the rules when it bothers you. So I looked at it. When I talked about the president striking a balance. Mr. McIntosh, Mr. Adler, how many rules do you think this president's EPA has proposed or finalized in his first 21 months? Just to guess if you want.
Major rules or all rules?
All rules. EPA only. Clean Air Act.
Just under the Clean Air Act?
Yeah.
My guess would be just under the Clean Air Act, probably under a dozen.
It's much higher. It's 87. And I was appalled. I couldn't believe it. I thought, well, who could be more liberal than that? And I thought, well, the Clinton administration. First 2 years, what do you think his numbers were? 115. Just there's a trend here. So I looked further. George W. Bush, first 2 years, 146. 146. So, I mean, Mr. McIntosh, you used the expression, I believe, and I don't want to misquote you, former member, that the courts force their hand on carbon. Does that mean you just disagreed with them?
No, what I meant by that was the court, I think, incorrectly interpreted the bill.
But isn't that, but back to the Constitution, now you're disagreeing with 2 out of 3 branches. Didn't the Constitution say that the executive enforces and then the Supreme Court interprets, and they interpreted? So you're upset with both of them now.
Well, at the time, the executive branch didn't share the court's interpretation. And I think there was a fair amount of evidence in the legislative history that Congress didn't intend that when they passed the Clean Air Act amendments.
Well, I'll be just, if I could, sir, please, let me just read you the language that you had a problem with, Section 202A1, which in its judgment causes, we're talking about carbon here that you don't have a problem with, which in its judgment causes or contributes to air pollution which may reasonably be anticipated to endanger public health or welfare. So we're talking generalities before, but now we're talking specific. You don't think that language implies that there could be a problem that someone in the EPA could reasonably interpret to endanger the public health or safety?
No, that section of the Clean Air Act was intended to give EPA the authority to regulate when substances that were, at the time that bill was passed, not known to be problematic for the health, become known to them. But at the time, people knew of carbon dioxide, and I would recommend you check with John Dingell, who was the author of it, and they did not intend for that provision of the Clean Air Act to give authority for EPA to regulate carbon dioxide. They talked about it in other parts of the bill, decided not to give that authority. But the language you cited, I think, is also a really important point for another issue that is very key to this whole debate, and that is how specific should Congress be when it delegates the legislative authority to the regulatory agencies? And there's always been a debate back and forth about whether general language, like the language you cited, is appropriate. The consensus is that it has been in the Clean Air Act in the language cited there, but I would point you to an article that I refer to in my testimony by a professor at Boston University, Gary Lawson, where he points out that if you had the Goodness and Niceness Act and said to the regulatory agency, promulgate rules for goodness and niceness and figure out what the punishment should be, that would be too broad a delegation. So somewhere in there, there's a spectrum, and the Constitution says no, the legislature can't delegate all of its legislative authority to the agencies. The REINS Act gives you the benefit of protecting against that, because for major regulations, they come back to Congress, and then there's a vote.
Only if you disagree.
Mr. McIntosh, I apologize, but the gentleman's time has expired. The chair would recognize the gentleman from Florida, Mr. Ross.
Thank you, Mr. Chairman. You know, it's interesting when we talk about the regulatory environment, and as a businessman, one of the things I've learned is that if I want to be profitable, if I want to make sure that I've got the right environment, I try to manage my risks. And the risks I look at, of course, are, you know, there's some insurance risks, there's the market risk, there's my resource risk. But one of the things I've learned is the regulatory risk that exists is almost not manageable. And the reason it's not manageable because there's no trends. There's no way you can anticipate what the regulatory environment's ever going to be if you want to start or operate a business. And in my particular state, there's a numeric nutrient water criteria that the EPA is trying to impose, coincidentally just on Florida, that my ag industry has indicated that it will cost over 14,000 full and part-time jobs, lose over $1 billion annually, cost my phosphate and fertilizer industry $1.6 billion in capital costs and $59 billion in operating costs. It would seem to me that this act, this REINS Act, would allow at least some sense of risk management over the regulatory environment. Wouldn't you agree, Mr. Adler?
Oh, certainly.
And with regard to even more imposition of regulatory schemes, I'm reminded back years ago when I was in the legislature, and this is on a smaller scale, but I was active in a Boy Scout group that had a summer camp, and they've had this property for 50 years, but they wanted to put an outhouse on there for the summer camp. But what they found out is that even though they had no running water, no electricity, they had to go get architectural drawings, engineer designed approved plans. They had to get, the DEP had to do a soil sampling. And by the time they were able to even get anything in order to meet with the regulatory system, summer camp was over. And what it taught me, though, was that logic and reason isn't always there. Now, I know that H.R. 10 exempts camping, hunting, and fishing, but without logic and reason, I think you also lack accountability. And one of the things, and I want to ask you this, Ms. Katzen, is would not the REINS Act allow for a greater sense of accountability to where it should belong, and that's in the congressional oversight of the regulatory environment?
As I said earlier, Mr. Ross, I strongly endorse the notion of congressional oversight. I have no qualms whatsoever with your committees calling up you call them bureaucrats, I would call them committed career civil servants and political appointees at the agencies, and ask them, what are you doing and why are you doing it and what's the support for it? I think that's wholly appropriate. But I would answer your earlier question to Mr. Adler differently. If you're worried about no trend, his answers to Mr. Johnson's question or Mr. Crowley's question was that there is no trend. Last year, Congress passed a health care bill. This year, it's going to be implemented, but it's going to come back up. And if one, not both, but just one house decides they don't like it, then it's not going to happen. And in 2 years, there'll be another election, and maybe the other chamber will feel differently. And the ability to predict what each election, and elections do have consequences. I do believe that, and I agree with that. But are you going to change then every 2 years the possibility that the rule is on, the rule is off, the rule is on, the rule is off, the rule is on, the rule is off? I think that leads to more uncertainty, less predictability.
So you would suggest that the status quo is more certain in terms of assessing the regulatory risk?
Of process. You pass a bill, you then turn it over to the executive branch to faithfully carry out the laws and to issue the regulations. I agree with Mr. Adler. An agency is not a free agent, cannot do whatever it likes. It can only do what Congress has said. But if Congress says, set the levels at this level, and the agency does that, it is faithfully carrying out
but wouldn't you agree
Congress enacted.
That in terms of accountability, that you have a greater degree of accountability where you have elected representation?
Yes, and the initial statute that was passed that authorizes the agencies is one that is fully accountable because it was bicameral and presentment. It was passed by both houses of Congress, and it was signed by the President. And the fact that now one house may think differently about it does not lead to greater accountability. What about the other house, which may like the idea? You've got gridlock, you've got problems. And I think those problems create greater uncertainty.
But with regard to gridlock, and again, and just to point out something real quickly here, in terms of the bill, the content of the bill says that within 3 days of the regulatory rule that Senate shall introduce their joint resolution. So there would not be, there would be an expedited fashion. So I did take issue with you there being gridlock there. But I see my time has expired. Thank you.
Thank you. On behalf of all of us, we would like to thank our witnesses for their testimony today. Without objection, all members will have 5 legislative days to submit to the chair additional written questions for the witnesses, which we will forward and ask the witnesses to respond as promptly as they can so their answers may be part of the record. Without objection, all members will have 5.
Mr. Chairman, I ask unanimous consent to enter into the record the CRS report on total costs and benefits of rules.
Without objection.
Thank you.
Without objection, all members will have 5 legislative days to submit any additional materials for inclusion of the record. With that, on behalf of all of us, thank you for your expertise, for your time, and your participation. This hearing is adjourned.